Hello everyone, Michael here, and today we have a special guest, very powerful, very energetic, and very helpful and needed. His name is Khaled. He is a real estate lawyer. He looks young, but he's very experienced. And before I bombard you with the question, just say a couple words, introduce yourself.
Thank you for the welcome, Michael. My name is Khaled Wahab, and I am a real estate lawyer. I've been practicing law for the last 5 years. Our law firm practices in the areas of real estate, family law, and estates planning and administration.
Sounds fantastic. All right. So my first question for you, Khaled, that's what my clients actually asks. My clients sometimes ask me, why do we need realtor? It's a different topic. I know how to answer. But the question is, why do a real estate lawyer need it in purchase transactions? Is it required by law or is it just good practice?
It's actually both.
Okay.
It is mandatory in Ontario to have a real estate lawyer look over your either purchase, refinance, or sale.
Okay.
It's mandatory by law. Ontario only allows lawyer to register or register a mortgage or a transfer through the land registry office.
Okay.
It's also a good practice to have an expert, a legal expert, review the documents, do the title search, and make sure that the whole transaction is binding.
Right. Yeah, and it's very important to review this document. They way too much complicated. Yeah, we always need a professional for that. And you specialize in all real estate transaction, right? It's residential, commercial, leasing, etc. What particularly?
I do specialize in various real estate transactions, whether it's residential, commercial, and we also handle more complicated types of transactions, such as real estate litigation.
Wow.
Sometimes if the transaction goes south,
that's challenging.
You do need a lawyer to take that forward to court. And a lot of lawyers will only do a solicitor side of the transaction, which is just closing the transaction. But if the transaction goes south, then they will refer you out to another law firm that practices litigation. However, we at Wahab Law do both, the solicitor side as well as the litigation side of the transactions.
So even if something happens and court has to be involved, you also can go with the client and follow them to the court and represent your client in the court.
Correct. So I have had transactions where I'm representing my client as the sellers or as a buyer, and the transaction goes south.
I see.
Now, my clients do not need to retain another lawyer or another law firm. I already know their case. I've been involved. I have all the evidence that we need to go to court.
Yeah.
And we just prepare the pleadings or respond to a pleading and take the matter to court. Clients actually like that better because now in the middle of their transaction, they don't need to go and look for another lawyer and then transfer our file to another law firm, and then they need to sit with a new lawyer, explain their case to them. So it's much more convenient for them to deal with a law firm that handles both.
Of course. Actually, this is a very good point because I had a client who unfortunately needed to go to court and something like that, and they had a lawyer and they built a trust, and but when it came to the court, he says, okay, now somebody else will represent you. So in your case, you represent from the beginning to the end.
That is correct.
Yeah, that's a very good point. Okay, so my next question for you. Okay, so we touched already why the law is needed, right? So, and sometimes something could happen. So, what are the most legal issues that can arise during the real estate transactions?
There are many legal issues that can arrive during a real estate transaction. Some of them being there's maybe a zoning issue. You purchase a property and the listing and everything says it is zoned for commercial as well as residential. But maybe when we do the zoning search, it's actually not zoned for commercial. It's only zoned for residential. So you have a zoning issue in this matter. Sometimes throughout the real estate transaction, you find out that there was a notice just registered. And now you have to deal with that with the other law firm and make sure that you have an undertaking from the other law firm to ensure that this notice or lien is basically discharged before the closing date.
Yes.
There could be a building search issue, that there was a building open work order that was not completed. There is a encroachment issue. There's a boundary issue with the other with the neighboring lot. So all of these issues can arise during any real estate transaction, but it's important to make sure for the lawyer to handle these issues before the closing date.
Oh, absolutely. As the buyer or seller, don't want to find myself in the situation that something happens after it's closed. So.
And that's why we have you would know this very well as a real estate agent, that's why we have the requisition dates.
Yes.
That's why we have the search date for the lawyer to do the searches and to make sure that prior to the requisition date, that the requisitions are sent to the sellers, and to make sure that your client as the purchaser has the title of the property free and clear from any encumbrances or notices.
And let's say you found something that wasn't there. People did want to worry about that, but you found something, requisition day. What's then? The deal is off? Or?
Well, it depends. Sometimes we'll even find something on title that was registered. Perhaps the requisition date has already passed and we have requisitioned what we need
Yes.
To ensure that our client has free and clear title. But sometimes right before the registration of the transfer on the closing date, we may find out that another lender or borrower came and registered a new lien on the property.
Wow, can it happen?
It can happen, and it has happened
Cool.
on some of our files. And in that case, although the requisition date has passed, but this was registered after the requisition date, we would request the seller's counsel, lawyer, to provide us with a new undertaking. Otherwise, we cannot close because this new lien or notice that has been registered on the title, it has nothing to do with our client. It's probably to do with the seller who are selling the property, and they loaned money to someone, or they owed money to someone, and that person now found out that they're selling their property. And the first thing that they will do, not that they have the legal right to, put a notice or lien on the property. And yes, to answer your question, deals have fallen apart because they are not able to get us, a free and clear title.
Right.
Because the person who registered it last minute requires those funds to be paid to them in order for them to agree to remove that or delete that from the title. So yes, it has happened.
Wow. I was sure before that law is needed. Now I'm more confident it's mandatory. Let's say what happens if deal is filled. Everything is good, but parties still have some sort of obligations, right, to fulfill. And let's say they fail to fulfill their obligations. What could happen in this way? So what the best way to mitigate this situation?
Where a party fails to mitigate?
For example, okay, so the closing day is December 1st. But the closing day, the seller didn't vacate the property. It didn't provide the key to the buyer. The deal is failed. What could be done?
So this can happen on both sides,
Of course.
where the purchaser is ready to provide the funds and obtain the keys, but the seller isn't able to provide a vacant possession of the property to the purchaser. In this case, the seller has defaulted on the agreement of purchase and sale. They're in breach of the agreement of purchase and sale. And in that case, well, it's not the fault of the purchaser because the purchaser was ready and willing and able to close on the closing date.
Right.
So they will be entitled to, likely based on how the contract is worded, their deposit back, return of their deposit. And the purchaser may have made arrangements to move into this property, and they may have sold their own property and now they have nowhere to go.
Yes.
And they will incur damages. The seller is also required to pay for the damages of the party, the innocent party, which in this case is the purchaser. On the other side, to look at it, there could be a case where the sellers are ready and willing and able to close on the closing date, but the purchaser has financial issues and cannot come up with the money in order to close the property.
Funds. Yeah.
Now again, based on how the contract is worded, subject to that, the sellers may be entitled to take the deposit, as well as seek further damages,
Yeah.
whether it's with their mortgage per diem interest rates
Mm-hmm.
or other arrangements that they have made. They may want to buy another property, and now they're going to default on that agreement as well. So all of this would be the responsibility of the party that breached the agreement.
I also think it could be based on the intention of the party, because if some breach happens and some of the party want to continue with the deal, but another party say, oh, maybe that's opportunity to get over the deal, so they kind of play with that here. So that's why you can help to mitigate it, correct?
Yes, of course. We always, as our role, when we shift our role from us being the closer or helping our client close a transaction as a solicitor, and where our role now shifts into being a litigator, before proceeding to court, our best method and plan of action is to make sure either to try to mitigate or to negotiate before proceeding to court, as we know that it is very expensive for the client and time consuming
Yes, of course.
to take a matter to court. It may be years before we see any results.
Wow.
It
And
is.
while they're waiting all these years, can they proceed with this property, or it's just like
No, they cannot. But at the same time, parties are required by law, by common law, to mitigate their losses.
I understand.
If a purchaser doesn't come up with the funds to close, the seller shouldn't be sitting on that vacant property for years before they get a result from the court. The court requires them to mitigate their losses. It will be the responsibility of the seller to actually list the property for sale as soon as they can,
Okay.
so that
So they can do it.
so they can sell the property.
Okay.
They can ensure that their losses are mitigated and controlled.
Okay.
And but if you just sit on it and you wait for the judge to make a decision, then your losses are going to be a lot more. And then the court may question you. What did you do as a seller when the purchaser did not close to mitigate your losses? You could have stopped the flow of your losses, but you didn't. Right? That could
Yeah, that's a
go
great
against
point.
you.
Very good point. General question: how can clients protect themselves legally when purchasing investment properties or handling rentals?
Investment property and rental properties are a little bit different in the sense that an investment property or a rental property may have many different units,
Okay.
and they may already be leased, and your clients are taking the property and assuming the tenants as well. It's important for the lawyer to not only do the regular standard searches that come with a residential property, but also obtain a copy of all those leases
Okay.
that the existing owner has signed with their tenants, to review the terms and conditions of those leases, discuss it with your client, ensure that the proper paperwork is done, that the tenants actually sign and accept the new changes that is going to be happening with the property, which is related to the ownership change, as well as make sure the tenants know that who to pay the rent to
Of course.
after the closing date. So somehow they're introduced to these new owners, as well as making sure that what the MLS listing said about the rents, about the tenants, are actually in fact true, and they all match. So that's there's additional work required with investment and lease properties.
So basically, when there's a property for sale and there's a existing tenant in the property, the seller can just say to the tenant, go, because I'm gonna sell it, right? Because it's against the law. So they are obligated to sell it with the tenant. So the buyer, my question is here, and a lot of my clients are confused with that address the question, so I better address it to you, Chuck. Do the buyer have to assume the tenant, or they have to say, no, I'm gonna purchase a vacant home, so you have to let your tenant go before that? From the law perspective, how is it done?
It's a little bit more complicated, because now we're not only dealing with the agreement of purchase and sale, which defines what the relationship between the buyer and seller is, and what the buyer is assuming and what the buyer is not assuming, but you're also getting into the Residential Tenancy Act, the RTA. that basically governs the relationship between the tenant and the landlord. The RTA actually states that in order for a landlord to give a tenant a notice of the sale of a property, the landlord must also basically provide a copy of that agreement of purchase and sale to their tenants, saying that the property has now been sold. But not only that, the new purchasers have to provide an affidavit. In that affidavit, the purchaser must basically state that they require the property for either themselves or their immediate family member for at least 1 year.
Okay.
So if you can provide the tenant with a notice, an eviction notice, together with the agreement of purchase and sale, together with an affidavit from the new purchaser, then you have met all the requirement to give notice to these tenants.
So who provides the agreement?
Generally, the
seller or the buyer?
It depends on the agreement of purchase and sale.
Okay.
So you can actually negotiate that and say, well, my clients require the property to be vacant.
Yeah.
So, and you can add that as a provision in the Schedule A or Schedule B and say that it would be the responsibility of the purchaser to provide the eviction notice to the tenants and provide a vacant possession of the property on the closing date. So now you've made it very clear that the seller would provide a vacant possession of the property and not your client. But in some cases, I've seen both. It says that the purchaser will assume the tenants and then the purchaser will provide the notice. So either or can, but the purchaser will have to give the notice after they take ownership of the property.
I got it.
But sometimes for a purchaser, it's much more easier if you put that burden on the seller or their counsel to make sure that they take care of that.
Yeah, very clear. Thank you. Now the deal is firm, perfect, and the seller has to provide the vacant property to the buyer, and provide the notice to the tenant after the firm, but the tenant didn't leave. So the buyer say, okay, there is a tenant in the property, I can't move in. What the right course of action here?
That actually happens a lot, where pursuant to the agreement of purchase and sale, the seller is supposed to be providing a vacant possession of the property to the purchaser. But on the date of closing, the transaction is closed. It could happen that the transaction is closed and then they attended the property and they find the tenants are still living together, living in the property. And the seller is in breach of the agreement because the seller did not provide.
So it's a seller's responsibility now.
If the agreement of purchase and sale says it's the seller's responsibility, then the seller is in breach of the agreement of purchase and sale.
I see.
And they're in default because they did not provide vacant possession of the property.
Correct.
And this is a very messy situation because now they will probably have to take the tenants to the landlord and tenants in tribunal, the LTB, and they would have to make a decision on this. Alternatively, this matter can also be taken to the courts by the purchaser, claiming that the seller are in default of the agreement of purchase and sale.
So basically, they can go to the court right away without
Correct.
LTB.
They can to seek damages because the sellers are in default of the agreement of purchase and sale.
I see. All right, yeah, that's a complicated part.
It is.
Without lawyer, the experienced lawyer, we
Yeah.
don't know how to deal with that and how to get out of that. But hopefully it's not gonna happen. But okay, when we talk to the lawyers, they say it happens.
Yes.
When we talk to somebody else, say maybe
It
it's
happens.
not
We
gonna
see because we closed a lot of transactions, so we see this on day-to-day basis.
Yeah, I see. So screening the tenant at the beginning can't help to not eliminate, but maybe to reduce the number of these issues.
Yes, it can actually. Either a lot of people hire a realtor to find a tenant. Some of them do it themselves, and there are so many different agencies now that go through a process of elimination and to check the criteria, such as their credit report, such as references from their previous landlords. Are they professional or not? And there are so many different factors to consider. Sometimes you get it right, and sometimes despite going through all of this, you get it wrong.
I have a system how to screen tenants well, and you just gave me the nice idea to create another podcast video about that.
Yes.
But it's off topic. So
Yes.
let's continue with other stuff. If you're talking about the commercial units or multi-residential, multi-unit residential, actually it's considered commercial, right? Because it's multi-unit. What are legal considerations should we keep in mind when we're going to deal with such properties?
Again, it's related to one of your previous questions where I said with multi-residential or multi-commercial units, you do need to check the zoning again. The zoning needs to be checked to make sure whether all of these units are zoned for the same type of zoning or not, or whether there is an allowance to change the zoning or not. Again, the title has to be checked by the lawyer. So those are the standard searches or procedures that we have to do. But in addition, these, again, we would have to check whether these units are rented or not.
Yeah.
Again, going back to the leases, checking and reviewing the leases,
Right.
the title, the zoning, the work orders, all of that. But there's more work as soon as you have multi-units, or whether it's commercial or mixed. There's more consideration that the lawyer need to look into.
Wow, you guys have a lot of work to do. With all the
We do, yes.
Yeah, sounds like very busy. Yeah? Okay, so I know people make mistakes. We all do mistakes, but if you hire a professional, we try not to make such mistakes. But what common mistake do you see usually buyers for sale makes, and how you can help them to avoid them?
Common mistake who makes, I'm sorry?
Buyers or sellers when they're gonna purchase or sell their properties, because they're not professional. Some buyers wanna buy just a property for themselves, and they don't know all the regulation, and they hire professionals, realtor who gonna help them, lawyer who's gonna help with all that you mentioned, title search, close the transaction, check everything that is clear. If they don't do some part, what mistakes can they make?
I think it's important as when a lot of times the agreement of purchase and sale are drafted by realtors.
Right.
For realtors to actually make it very clear to the sellers before listing their property that you're not an expert at evaluating the property.
Right.
You're not an expert at construction or renovations or telling them where the defects are in the property.
Right.
So that they're not relying on you for those things when they're listing their property.
Yeah.
A lot of the mistakes that a seller may make when they're listing the property, they're not disclosing everything. They may have knowledge of defects or leaks in the property, such as a leak in the basement that has been happening for years. But when it comes time for listing the property, they cover it up.
Yeah.
And then the new purchaser finds out when moving into the property.
Yeah.
Now there's a claim against them. And they may blame it on the realtor.
Of course. Yeah.
Right?
Who else?
So that's why it's very important for realtors to make that very clear to them, that you're not providing them any advice in terms of where the damages are in the property.
What I mentioned in another podcast of mine, so also I spoke about that when I represent the buyer and we come to close the deal, and it doesn't matter for me if it's multiple offers and a lot of demand for that. It's very hard to win the case. I always suggest my buyers do inspection. Do inspection because it's very important. If you're going to win the deal without this inspection, you might find yourself in not very pleasant situation.
I understand when the real estate market was very hot.
Yeah.
The inspections were out the window.
Yeah.
If you put an inspection as a clause or a condition in the agreement of purchase and sale, you were automatically rejected.
All right.
But I'm liking that is we're going back to putting the inspection clauses in the property,
Yeah.
which reveals a lot of the defects that are in the property, and the buyers are making an informed decision. But I'm keep hearing that with the interest rate going down again, that we might not see these clauses again in the agreement of purchase and sale.
Oh, yeah. Yeah. The last question for you. First of all, it's very helpful. Khaled. Thank you very much for that stuff. Just what would you recommend or advise for the first-time home buyers on today's markets?
For the first-time home buyer, look into the market in terms of the first thing that they would need to select is have a knowledgeable realtor on their side who understands the drafting of the agreement, who understands the market, who understands their needs. Because you as a first-time home buyer should explain to the realtor what type of property do you require.
Right.
And if they understand you, then it's much more easier for them to show you the exact type of property that you're looking for. Second thing is also finding a very knowledgeable mortgage broker or advisor on your side, where you want to make sure that they will get you approved and get a pre-approval before you even ask your realtor to look at houses for you. You do not want to spend your time looking at properties that you cannot afford.
Of course.
Or even waste the time of your realtor by them showing you the properties that you cannot even purchase.
Right.
So if you have a pre-approval, you know the target market or the category of property that you should be looking at. And then it also helps to find a knowledgeable lawyer that can also assist you with these process, where having them involved early on will help you avoid many of the issues that we spoke, whether it's with drafting, whether it's with clauses that should have been in the agreement are not there. If you have all of these three professionals on your side and they're working together, you're going to avoid many of the common pitfalls that a lot of other first-time home buyers go through.
All right, Khaled, thank you very much. Very powerful, very informative and knowledgeable information. I like it. Now, as I already mentioned, lawyer is needed, professional is needed, everybody else needed who is a professional hire. So thank you again for coming here, and hope to see you again here very soon.
No, thank you. Thank you so much for the invitation. It was a pleasure speaking with you.
Absolutely.
I hope this was very informative to your audience, and hopefully we can do this again. And for those of you who would like to retain our services, either for your client, for anyone watching, our main office is in Kitchener-Waterloo, as well as we have our second office here in Remax One Realty Brokerage in North York in Toronto. So you can always get in touch with us. Our phone number and email will show on the screen for everyone who would like to contact us. Once again, thank you so much.
Thank you, Khaled.
Pleasure.
Thank you.
Thank you.